My learned brothers and sisters, this is Advocate P. Devmorari talking to you from Ahmedabad city, which is our state, India, that is our Bharat. Today I have selected a very good topic from criminal law, and it is for public servants, government servants, and that is from Bharatiya Nyaya Sahita 2023, section 132. Now equivalent previously it was Indian Penal Code, section 353. Assault or criminal force to deter public servant from discharge of his duty. This is the title. Now I'll read out the section, BNS section 132. Whoever assaults or uses criminal force to any person being a public servant in the execution of his duty as such public servant, or with intent to prevent or deter that person from discharging his duty as such public servant, or in consequence of anything done or attempted to be done by such a person in the lawful discharge of his duty as such public servant, shall be punished with imprisonment for either description for a term which may extend to 2 years, or with fine, or with both. Now, what are the ingredients of this offense in short? Assault must have been made or criminal force used. Number two, assault or use of criminal force must be against public servant. Third, in the execution of his duty. Fourth, to prevent or deter. Fifth, in consequence of anything done or attempted to be done by such person in the lawful discharge of his duty. Punishment last. BNS section 132, previously IPC 353, punishes an act which may be causing an obstructions in discharge of the public functioning of public servant, either by assaulting or using criminal force to such public servant, causing some violence and physical injury to complainant public servant by accused is necessary to constitute offense under section 353 IPC or BNS section 132. Means there must be some physical injury or violence. Otherwise, this section is not attracted. Assault must have been made or criminal force used. Assault or use of criminal force is a necessary ingredient of the offense under this section. Citation 1963 in bracket 1, Criminal Law Journal 559, Tripura. Snatching of the ballot papers during election time from custody of polling officer and tearing them would be a case of use of criminal force covered under section 353 of the Indian Penal Code. Citation is 1997 Criminal Law Journal 3416. A mere act of hurling abuses is outside the scope of 353 IPS section 353 or BNS section 132. So simply by abusing any person, nothing is attracted, no punishment. But the accused attacked the police constable while being taken to police station in execution of search warrant. The actual causing of injury is not necessary. The offense being serious, no leniency could be shown in imposing sentence, and conviction under this section was proper. 1993 Criminal Law Journal 1301. Assault or use of criminal force must be against public servant. This is a condition. Before proceeding to convict an accused under IPC section 353, now BNS section 132, a measure should deal with the question of guilty knowledge on the part of the accused and the question as to whether He knew that the person assaulted was a public servant. Accused must have knowledge that he is a public servant. Year 1933, Sin 174. A police constable must be considered to be always on duty as a police officer when interfering with breaches of the public peace within the station limits and jurisdiction, whether in mufti or in uniform. Even if he's not in uniform and somebody is committing an offense in his area, like breach of peace, then also section is attracted. Year 1950, Madras 365. When accused person took wooden stool to throw at complainant public servant, and other co-accused took out his shoes and threatened the complainant with dire consequences when he would go out of his office. Such acts of accused persons do amount to assault on complainant while he was discharging his public duty and make them liable to be convicted under Section 353 IPC, equivalent BNS Section 132. When accused person by flirting shores aimlessly in air frightening police party in order to prevent their apprehension, they are liable to be convicted under Section 353 IPC or at present BNS Section 132. In the execution of his duty, in definition I have said this, phraseology. The word duty as such public servant mean duty imposed by law on such public servant and do not include acts done in good faith and under color of his office. The words in the execution of his duty in this section can only apply when the public servant is discharging his duty imposed on him by virtue of his office. Duty imposed on him by virtue of his office will include the performance of all acts which are so integrally connected with his duty attached to his office so as to form part of it. Now this is the Supreme Court judgment, year 1975, SC 1685, equivalent 1975 Criminal Law Journal 1490. In absence of good faith on the part of public servant, the resistance offered to him will not be an offense, even under Section 362 IPC, BNS Section 138. Year 1932, Patna 66. To prevent or deter. We have read these words in definition. IP Section 353, equivalent Section 132. The terms prevention and deterrence are not synonymous. In the first place, prevention does not mean only deterrence by physical force, by other means as well. Secondly, the distinction seems to be with a reference to the stage of interference by the accused. Citation. Yeah, 1953, Madras 936. Now I'm reading very good citation. Where an allegation laid that persons gathered in marriage ceremony obstructed vehicle and caught hold of deceased police officer. While the main accused shot him dead, the facts clear that it was sudden act on part of main accused and the other accused neither participated in the attack on the deceased nor the cause any injury to them. The common object of unlawful assembly was to deter police from discharging their duties and not to commit murder. This is a very important topic. Conviction altered from 302 to 1 under Section 353. This is a very good sentence. 353 means at present Section 132. In consequence of anything done. The expression in consequence of anything done as used in section 332 IPC, that is, voluntary causing hurt to deter the public servant from his official duty. And this section, IPC 353, includes the motive which actuates the accused to cause voluntary hurt or commit the assault as well as the cause of such assault. That is 64 in bracket 1 Criminal Law Journal 254 Rajasthan. That's all in this video. Hope you have got some good information. You have enjoyed this. Please subscribe it, like it, and share it. Thank you, thank you, thank you.